SJC-12251, Commonwealth v. Fernando R. Perez.
Ms. Caddick, good morning.
Good morning. May it please the court, Elizabeth Caddick for Fernando Perez. The cornerstone of the Eighth Amendment is that punishment should be proportional to both the crime and the offender, and that this should be evaluated using contemporary standards of decency. Using those elements, looking at the sentence that Fernando Perez is facing now, he, as a 17-year-old at the time of the offense, is ineligible for parole 12 and a half years longer than a similarly situated 17-year-old who was convicted of murder or even multiple murders. This is an untenable difference between the offense and the sentence. Also, when you look at what was known about Mr. Perez at the time of sentencing, that he had a highly traumatic childhood, was particularly vulnerable to the influences of older people. Evaluations of his mental state performed almost 2 years before the crime, and not as some after-the-fact justification for his actions, showed that he suffered from PTSD because of the violence of his father and the multiple moves of the family to avoid the violence of his father, and that he was described as walking on eggshells, always eager to please everyone, not able to stand up on his own. And what happened 2 months before this particular crime is that his beloved uncle himself was murdered by his uncle's wife, and so of course there was this sudden death, and he was quite affected by this. 2 weeks later, in steps this other uncle who had a criminal past and who himself was violent and domineering. And to a certain extent, because of his history, Mr. Perez thought that this was normal. He was easily manipulated by his uncle. He's a boy who had no prior criminal record, was working hard. We have the evaluations of the probation officer and the aid in sentencing psychologist appointed by the court, who all spoke about how his uncle was the factor that caused this crime. He was easily manipulated by his uncle. And we have the words of this sentencing judge, who at the time in 2002, without all the benefit of the later research on juvenile sentencing, didn't appreciate the fact that a juvenile's brain leads them to be more susceptible, particularly someone who had the upbringing that Perez had, who could not extricate himself from this upbringing. And the judge thought that he couldn't consider that. He says, well, he's 17. The law says I have to treat him as an adult. He appeared to think that somehow all of this information from the different psychologists and probation officer about his youth and his ability to be easily manipulated, that somehow that had to just go to excusing his crime. He didn't appear to appreciate that it should go to his sentencing. And that's because, again, it was 2002.
So what relief specifically are you asking for?
He should be resentenced using the Miller factors as described by this court in Costa, when this court remanded Costa for a new sentencing hearing, and that using those factors, the court should resentence him using, not just stating, but using the Miller factors that adopt all of the psychological, social science research on the juvenile brain. And also, as this court had stated in Costa, the resentencing court should look at his behavior, either positive or negative, post-sentencing.
When is this triggered? Obviously, your client is well past the parole eligibility, but when, in your view, would that type of remand Miller, Dechenko finding be triggered? Under what circumstances?
I think any case in which a juvenile is now serving a sentence such that he is ineligible for release later than one convicted of murder.
We look at parole eligibility for murder, and that really anything beyond that should have Miller hearing attached to it.
So parole eligibility for murder, murder one, murder?
It should be murder two. The amicus brief says simply murder, not murder one, murder two, and I think that's well argued. So it would be 15 years.
So any sentence longer than 15 years?
Or parole eligibility.
Parole eligibility longer than 15 years.
Exactly, right, a meaningful opportunity for release. So it could be parole eligibility, it could be that his prison sentence ends in 15 years, but he then has.
It doesn't, like in Costa, it doesn't mean that a person could still theoretically do a 40-year sentence.
Yes, exactly. If their behavior post-sentencing shows that perhaps they haven't matured. It wasn't just that they were in the throes of the usual juvenile brain and that they've matured, whereas it's clear Mr. Perez, matured. And in fact, he really never had a impulsive behavior. He was always considered a good kid, easy to please, or eager.
So how do we get there to where you want us to be? When the rule was articulated in Miller and Decl, it was because the person had no possibility of being reviewed for parole. But that's not the case here. He had a sentence of a certain number of years. He's going to be eligible for parole at some point. So how do we get the Decl rule to apply to this case? What's the analysis? What's the hook? I'm trying to figure that out.
It's proportionality. It's that the constitutional underpinnings of Article 12 and the Eighth Amendment is that the sentence has to be proportional to the crime and the offender. And we know that the offender, a juvenile offender, it goes along with Miller and Decl, but the crime is less than murder. So any non-homicide juvenile should not have as his time for a meaningful opportunity at parole to be greater than that of a juvenile convicted and sentenced to murder, either first or second degree.
So in this case, if the shots that he fired at the officer had killed the officer, and he were found guilty of felony murder first degree, which he likely would, and he were convicted of the other 2 robberies, and they were made consecutive, when would he be eligible for parole?
Well, it would actually, so that was 2002. I think that was right about the time the consecutive sentences, the calculation of them was changed, so I don't know. It was more beneficial to the defendant, I think before 2002, where they combined them. But if that were the case, that he had 15, what it would have been is after 15 years, then he would have, if it was the way it is now after 15 years, then they look at when he would be eligible for parole on the next case. But the way they did it, possibly at this time, is they put them all together. So, for example, someone who has 2 consecutive life sentences is eligible for parole after 15 years if they were sentenced earlier. If that were the case, I would still be here because just like Costa was before this court, where he had consecutive sentences, but it was before 2005, before we had Roper, Graham, Miller, Diachenko, and so this case would just be a natural progression of all of the cases dealing with juvenile sentencing that went before. And this refers to just a particular non-homicide defendant whose meaningful opportunity for release is later than that of one convicted of murder.
But you agree that where we are right now is that the only sentence that's unlawful is life without the functional equivalent of a real parole date.
Well, I would say that this court has not yet spoken and said that any sentence other than that is unconstitutional. I think that it is unconstitutional now, just hasn't been pronounced yet because based on this court and the Eighth Amendment and Miller, Graham, all speak about proportionality.
You want us to go further than functional equivalent of life, because functional equivalent could be anything from 45, 50 years onward. You want us to stop at a bright line rule at parole eligibility past 15 years.
Right, because that's what it is for second-degree murder.
For proportionality.
Right. And also what's happening with these older sentences, like Mr. Perez has, there are statutes that came about later. For example, a statute that says that a youthful offender, up to 17, can't be denied moving to minimum prison, can't be denied some of these programs that other people are denied because their time for release is so far away. That's what's happening to Mr. Perez. He's been at low risk for years and years, but because his out date is 12 and a half years from now or 12 years from now, he's not, and the rule at the time and the rule he's suffering under now is that he's not eligible to move to a minimum until his possible release date is 5 years or less. And so there are so many reasons that people in his position should have an opportunity to be resentenced based on Article 25, just because society has evolved since he was sentenced.
Yeah. Now, Costa, of course, was not decided on constitutional grounds.
It was a 30A, and that's what this
And there
case
was
is.
a question about whether or not the judge could do it.
Right.
And in Costa, we said he could do it.
Right.
We didn't say how it had to come out.
Right, although I think Costa and what the trial judge did in that case on remand is important. The judge said that he believed, had the sentencing judge at that time known of all the research on juvenile brain development and known that juveniles aren't, as this sentencing court thought, doomed to always be violent and doomed to always be a menace to society, that he probably would not have sentenced him.
Now, so I'm a little confused here because basically in Costa, we sent it back saying the judge could do that. And if he did it, he had to do it this way, using these factors. But here, Judge Ford declined, even though he knew he had the discretion to do it, right?
Well, but
Did he have to resentence? Are you saying that, or if he did have a resentencing hearing, are you saying he had to resentence?
He didn't have to
some
resentence.
period of time for parole eligibility at no more than 15 years? I'm trying to just sort of poke at what it is
Right.
you're really looking for
Okay.
here.
I believe he should have a new sentencing hearing, and that's what he's entitled. It's a new sentencing hearing under Miller factors, as detailed and additional factors as detailed in Costa, and it's not based on the law that allow Costa to get resentenced. It's based on the law of Roper, Graham, Miller, Diachenko, and the evolving standards of community decency.
But
And-
if the issue is proportionality,
Yes.
why should we not simply say that the sentence is the same, but he's eligible for parole after 15 years, which is what he would have been had he been found guilty of felony murder?
Well, because he's entitled to a new sentencing hearing also based on, because it's so old, it's also based on the fact that he now has a 10-year probation from and after his release, and the Superior Court Sentencing Commission now recommends that probation probably be no more than 3 years, but also if there is a from and after probation sentence long after that's ordered, but then the person spends a long period of time in prison, whatever those conditions of probation were, whatever the length of probation was, is probably irrelevant because it's supposed to refer
So
to.
should we have resentencing for everybody who's incarcerated who has a long sentence and has a from and after probation?
No, but certainly in its additional reason to have a new sentencing hearing for Mr. Perez and those like him who were sentenced to long sentences leading to a greater than 15-year possible release time prior to all of the research on juvenile brain development. It would not be opening up the floodgates. Most of the work would be done by the criminal defense attorney, who does all the research beforehand, presents everything to the sentencing judge, and also, this court to find out how many juveniles really do fall in this category. It may not be that many, but certainly they're all entitled under Article 26 to have a new sentencing hearing with all we know now about juvenile brain.
Okay, thank you.
Thank you.
May it please the court. Good morning. My name is Elizabeth Dunphy Farris. I'm the legal counsel for the district attorney in Hampden County, and with me today is Katherine McMahon, an assistant district attorney for Hampden County. I was the trial counsel for the Commonwealth in the case against Mr. Perez, as well as his uncle, Mr. Abrante. The Commonwealth's position is that the sentences that were imposed by Judge McDonald on January 4th of 2002 were legal then, and they remain legal so today.
If I can ask you the same question I asked your sister.
Yes, Your Honor.
Let's assume that those bullets which he fired at the police officer had killed him as opposed to seriously injuring him, and he is found guilty of felony murder and of all the other convictions. When would he be eligible for parole?
Under 279, Section 8, which is the statute which deals with a judge's ability to impose consecutive sentences, to the extent the only difference is that Mr. Perez received a life sentence upon the felony murder. His parole eligibility for the murder committed at that date would be 15 years. As to the 3 distinct armed robberies,
Well, there are only 2 distinct, because one would be merged with the felony murder. Oh, you mean
there were
because
3
there
other
2 people?
victims,
Because- okay,
and each
yeah.
of those victims had a separate conviction for armed robbery. Each of those, at that time, carried a minimum of 5 years up to life. If the sentences that the judge imposed, which were 5 to 7.5 on the first robbery, Mrs. Jane's, and then 5 to 5 and a day, that would be another 10 years, so he would be at the minimum facing 25 years. However, the judge would have had the discretion to sentence anywhere between 5 years to a life for each of the armed robberies consecutively.
Well, there's no reason to think that if he
I'm
killed...
sorry, my question was not the potential length of the maximum sentence. My question was the parole eligibility. When would he be eligible for parole?
Considering that the only charge would be that Officer D'Amato died,
No,
as
I'm
opposed
saying
to...
with all the other charges. Let's assume the sentences were the same except with respect to the armed robbery of Officer D'Amato. And let's assume that was a felony murder. When would
Yes.
he be eligible for parole had he died?
15 plus 10 as a minimum as to how the judge sentenced.
15 plus 10 because it would be on and after the life with regard
Yes,
to parole?
he made-
And what is your basis for saying that?
The trial judge made all
Basis in the code of, in the Mass Code or by statute with regard to the parole eligibility date?
the statutes as to the armed robbery, because the minimum mandatory period for an armed robbery committed with a firearm at that date was 5
You're
years.
saying it would be minimum mandatory after life?
Yes, Your Honor. If you adopt the way Judge McDonald sentenced Mr. Perez, he sentenced him to 5.5 to 7 years, 5 to 7.5 years.
Do we know if that's how that has been interpreted by the parole board? Do we know that the parole board has viewed the minimum mandatory with regard to a life sentence to be on and after the parole eligibility date?
Under 279, Section 8, it says when a defendant is committed under sentence, multiple sentences, they are committed at one time, and there's an addition of the times of commitment, the terms of years of commitment. So I believe that is the statute which allows for the addition of life plus. In addition, the judge in this case, knowing he had discretion, made the sentences consecutive. It's not for everyone who commits, and the judge in a murder case may not have chosen this type of sentencing scheme, but with all else equal, and the only difference being the last, that indictment 154, which are the last two charges that deal with Officer D'Amato. If those sentences are taken away, they add up to, he received 9 years, 364 days on assault and battery. And on assault with intent to rob, he received a 7 to 10 year sentence. So,
I'm just looking at 120 CMR 200.8, subsection 3. A sentence for a crime committed on or after January 1st, 1988, which is ordered to run consecutive to a life sentence, shall not be aggregated with the life sentence for purposes of calculating parole eligibility on the consecutive sentence. Are you aware of that particular provision?
but there is a minimum mandatory
Right, but
here,
that
Your
assumes
Honor,
that the
and
minimum
there-
mandatory is going to be viewed as commencing upon the conclusion, commencing upon the parole eligibility date. I mean, it's a strange thing to have on and after life. But you're basically saying, oh, that would be interpreted by the parole board to say that the on and after means it starts upon his parole release.
I believe the
That's how it's
legislature
calculated.
would have to amend 265, Section 17, armed robbery, to allow for that interpretation of the CMR.
Can I ask you a question about overall?
Yes.
Because there wasn't a felony murder.
Correct.
What's your position as to whether or not a judge can sentence someone past the 15-year parole eligibility and give them the functional equivalent of life? So here the defendant was sentenced to 34 years. Suppose he was sentenced to 50 years. Do you think he should have a parole eligibility date less than the 27 years he has in this case?
Not less than the 27 years he had in this case. I do believe that there's an argument.
Is there a tipping point, in your view, about functional equivalency under Miller and Dechenko?
Well, I believe this court cited a number of cases in Brown, and I've also cited additional cases that have come down since Brown that suggest that the functional equivalent is not 30 years and is much greater in the range of, I believe, the shortest in which a court of another jurisdiction has found functional equivalent using Miller factors in the Miller case is 45 years.
They
The
seem
parole
to-
eligibility, they all received, in many of the cases, the juveniles received life sentences. There is case law cited in the brief where there are states which now do deem term of year sentences that are imposed consecutively bring into play a functional equivalent analysis of life without the possibility of
How do
parole.
you take into account our case law under Dechenko, which deviates from Miller?
Yes.
In many, in the big regard about parole eligibility? Because I understand the case law that kind of hovers around 45 years, but our case law is different. On the
This
Decl.
case, this court stated that it was not stating in Costa that a sentence of 30 years was the functional equivalent. It based its decision on things other than the Constitution, but rather on the integrated sentencing scheme. And that, the court's belief that the sentencing judge in Costa was rather symbolic in what he did in relation to sentencing the defendant to consecutive life without parole sentences. In this case, the sentencing judge rejected my recommendation at the time, which was for a life sentence plus a 20 to 30-year concurrent sentence in a general sentencing scheme, and said that he wished to sentence for each of the crimes for which the defendant was held responsible by the jury, and that he did so taking into account not only the defendant's life experiences, which are set forth in the trial testimony of his expert, as well as her report for the purposes of sentencing and the aid in sentencing, but he also said that he took into consideration the impact on the victims. And he specifically said that he was rejecting the defense recommendation for a term of consecutive sentences less than what the Commonwealth recommended and less than what he was going to sentence to, because to do so would make it, in his mind, in the way he chose to sentence, the defendant would receive no penalty for his shooting of Officer D'Amato and his attempt to rob him. And he said that he could not do that, and that he believed this defendant should do 27 and a half to 32 and a half years. He is parole eligible, not in 12 years. He's parole eligible in less than 10 years now.
Is that in his early to mid-50s, is that right?
He's 30, his date of birth is 8/16/83. He was 17 years, 4 months, and 7 days at the time the crimes were committed.
Can I ask you a question? Suppose Judge Ford had done the opposite. Suppose he'd said, I have the discretion to do this and I'm going to resentence him. Is there a problem with that?
In the Commonwealth's belief, yes. We argued that the defendant finished serving all the two sentences that were related to the first set of indictments, which is 120. Because those sentences were 5.5 to 7 years to 5 to 5 and a day. That he is currently serving his 7 to 10 year sentence, and that the
Is the police officer related one?
yes, the indictments related to the
So
police.
suppose the judge had just said, I'm going to reduce that substantially. Could he do that?
No,
Because?
there is nothing within this court's interpretation of the Miller case in Decl and its progeny that suggests that an imposition of consecutive terms of years sentences that are greater than 15 years amounts to cruel or unusual punishment.
So you're saying
In
that unlike in Costa, where we said the judge did have the ability to do this, you're saying this case is substantially different than that, and that really Judge Ford had no choice but to do what he did. Is that what you're
Yes.
saying?
Yes. But
So,
I would point out to the court, and I'm sure you're well aware, that in Brown, the defendant began to make the argument about the imposition of minimum mandatory sentences, and this court rejected an argument to go that far and said that it was not the reason why it did Decl, that just the factor of time is at issue. And I would believe that the legislature may choose to change 279 Section 8 as it pertains to juveniles, or to change any of the parole eligibility statutes as it pertains to juveniles. But in this case, it's the Commonwealth's position that this defendant appealed his sentences under 278 Section 28B to the Appellate Division of the Superior Court, and the Appellate Division of the Superior Court dismissed his appeals after hearing as having not been excessive in relation to the sentences that were imposed. And under Woodward and a number of cases from this court has said that the Sentence Appeal Division is the final word on the excessiveness of sentences per numbers. To the extent the defendant is making a constitutional argument, he extends the court's reasoning in Decl, Brown, and Costo to a point this court has not taken previously and rejected, in my opinion, in the Brown case when presented to go that far by defense in their argument. And I would suggest to the court that that he is not procedurally have available to him Rule 30, at least under 120, under 150, the indictment 120. Under indictment 154, which are the indictments of the sentences he is now serving, the defendant can make the argument, but his sentences there, and all of the sentences there, are within statutory limits. There is no argument here made by counsel that any of the charges for which the defendant has been convicted of should not be life felonies for juveniles.
So if the judge had imposed a sentence of 100 years on the armed robbery,
I believe that there would be a functional equivalent argument made under Article 26 as this court's decisions are being interpreted.
Because it exceed 45 years, under your view?
I don't know what the
Do you have a
lowest...
do you have a magic number?
I don't, Your Honor, but in reading the reasoning of other courts that have dealt with numbers, it appears that it is something at least twice what this defendant received in the aggregate.
Shouldn't the defendant get the benefit of having somebody take a look at the sentence in light of Miller? Nobody's done that yet.
Respectfully, no, Your Honor. I don't, first of all, I do believe that Judge McDonald, may I continue?
yes.
I do believe that Judge McDonald did take in light the factors of the defendant's difficult upbringing. I believe that he specifically said that he was aware of those factors, but that he was rejecting those factors and the factors that my sister has put forth that she wishes to present other than
But that was
his
pre-Miller.
institution.
That was pre-Miller. That was before the Supreme Court said there is a difference between juvenile offenders and adult offenders.
Yes, but the Miller factors, as they are interpreted by this court in Decl, which is the constitutional ground for Massachusetts, are not that the Miller factors are what a sentencing judge had to take into account previously. It's what created with the addition of the constitutionality of life without parole being that a juvenile was irreparably unable to rehabilitate himself. A conglomeration of all of those factors brought the court to say life without parole is not a sentence that we are going to allow judges to place upon a juvenile because we know the social science says there can be change. Where a judge has taken into consideration the psychological impact of a defendant's previous life, which he did in this case, in which it's the same type of psychological evidence that my sister suggests we should take into consideration here, and has rejected it in favor of the sentencing scheme that he has put forth here. It's the Commonwealth's position that the functional equivalent has not been met, and there is no disproportionality. He is at the lower end of the sentences are, when you aggregate them, they come up to 27 and a half years, but each of the sentences imposed, except for the one on assault and battery by means of dangerous weapon, in which he received the maximum, he is at the lower end, if not the minimum, that he could have received. So he clearly is not at the constitutional end of the most severe sentence that could have been placed on him. He faced 3 life sentences, 4 minimum mandatory 5-year sentences.
Okay, thank you.
Thank you.